Hi, everybody. How are you? Good afternoon. Did they promise you a tropical vacation or what? Is that enough tropical for you? We can do more tropical. I mean, you know, a little bit, I understand. It's maybe a little sad that we don't have more sunshine, but from what I've seen and the folks that I've talked to, the place is beautiful. The people are beautiful. It's absolutely a pleasure to be here. Thank you very, very much to Michael and your team for inviting me to join you, speak a little bit about disability rights and resources. It's a pleasure. Thank you so much. So my name is Christopher Knauf. I'm with the, maybe not. There we go. I'm with the Disability Rights Legal Center in Los Angeles, just up the road. And my wife and I just got into town. We've already had fish tacos. Who else has had fish tacos since you've been here? Raise your hand. This is okay. One fish taco. Okay. Yes. More fish tacos. Yeah. That's what we eat here in San Diego. We eat fish tacos. So please, enjoy. I wanted to get to know you a little bit, and that will actually help me tailor my remarks a little bit from what I've prepared for you. Got a good number of folks in here. I want to know how many of you are from California, anywhere in California. Please raise your hand or answer audibly. Okay, we've got some, I can sort of see through the lights a little bit. Yeah, thank you so much. Okay, so we've got some Californians. We got a lot of folks from out of state. Do we have any teachers with us? We've got some teachers with us. All right, excellent, excellent. We'll talk a little bit about education. Do we have any lawyers with us? Okay, we're gonna need those folks removed, okay? Because that's just bad news. No, just a couple lawyers, but in any case, I've been practicing for over 25 years. My wife and I actually graduated the same time. We were just saying we're starting our 26th year of practice, and it just kind of blows our mind. But I've actually been doing disability rights and public interest law for my entire career. It's been, you know, a work of passion of mine. I've loved representing folks with disabilities, you know, in litigation matters. I primarily litigate. So contractual matters, maybe those two can talk about, but I'm going to talk to you about civil rights and civil rights litigation. I'm going to talk about some of the laws that apply to all of us, and the laws and what happens when you want to enforce those laws, or if you have questions, what do you do? And I'll try to demystify the process a little bit. And, you know, we'll take your questions afterwards. So which brings me to the next slide. Yes, this is a general overview. I am not here to answer all of your legal questions and give you, you know, all your roadmap to the lawsuit that you want to bring, but I'll give you a little information towards how to do it. And if it's something that you're interested in, I encourage it. If you've got a good issue, one of my messages is I want you to enforce your rights. I want you to hold folks accountable for the things that they, you know, are doing wrong, and perhaps intentionally, perhaps unintentionally. But the fact of the matter is, the reason why I do disability rights and my office does disability rights, we want a level playing field for everybody. We want equal opportunity. We want proper accommodations. We want to avoid discrimination, and we want to hold those accountable for when they commit it. Yeah, thank you so much. Yes, I agree. Every single one of us and our loved ones, we should have an equal opportunity to live the independent life that we want to live, right? And that means the freedom to make mistakes, right? Just live, baby. And so I'm going to talk about various mechanisms in the law that are designed to promote that idea towards equal opportunity for independent living. But please be advised, general overview, not legal advice. Please consult an attorney, and you can consult us afterwards if you like. Happy to consider any matter. Okay, so we already talked about why we're here. I got a little sense of who you are. I'm going to assume we all ourselves or someone close to us has a disability that meets the definition under federal law. I'm not going to go tremendously into that. You may know what the definitions are already. I'll go over them a little bit. But we'll do a presentation about mostly federal law and then the legal process. And then Michael has asked me to have ample time for Q&A which I'm happy to do. And by the way, the Q&A can be here in person, with a microphone, or it can be emailing me or approaching me after the session. I'm happy to chat with folks. Okay. All right. So disability rights, federal law versus state law, and federal courts versus state and administrative courts. So the laws I'm going to talk about today are all federal laws. Congress passed them. They apply to everybody in the United States and territories that are within jurisdiction. State laws can and often are quite different and even more protective. All the folks who raised their hand for the California question, congratulations, you have greater rights than the rest of the country because California has enacted statutes that are more protective of folks with disabilities in California and provide greater remedies. For instance, under federal law, you can't get damages for, say, a barrier removal case. Under Title III of the ADA in California, you can get damages because it acknowledges that the simple act of discrimination, whether or not there was true financial damages, hurts, and that real discrimination warrants an award of damages. So kudos to the California legislature for going above and beyond. And that's true in other states as well. I know New York has some protective statutes across the country. Each state has different disability rights statutes. And if you're whatever state that you're from, as you'll hear later, I'm going to encourage you to consult your state disability rights office and or your state legislature. Sorry, I should go on airplane mode, shouldn't I? That'd be a good idea. Sorry, in any case, the cases that we're talking about or the cases that we bring are typically in federal court with a federal statute, but not always. In fact, in California, there's a lot of statutes that we can bring in California state courts. What's the difference? Not a tremendous amount. The different locations where you can file suit, their state courts in California are all over the state. Typically, federal courthouses are in one major city or a couple major cities in a state. The judges are appointed, confirmed by Congress, and have life tenure, whereas state court judges are not necessarily, depending on the state constitution. They are often elected and are accountable to the people. So where we file federal versus state really just depends on the particular case at hand. It depends on the issue, depends on the desired remedy, but we have those different locations to choose from, which can be very, very helpful depending on the case. And then we file in federal courts, we file in the state and also administrative courts. So we'll talk a little bit about special education today. Those are all filed typically in administrative tribunals in each state, which is a little bit different than the state and the federal courts. Now, the appeals of special ed cases, those can go up to the typical state and federal courts and all the way up to the Supreme Court if necessary. Okay, what's next? Come on, clicker. Ooh, I pressed the wrong button. There we go. Okay, so here's a list of several federal laws that we'll talk about today. I'm going to touch on a couple. I'm going to take a few and go a little bit more in depth. Michael had suggested that GINA, my good friend GINA, a Genetic Information Non-Discrimination Act, might be something of interest to the DM community, and I completely understand that. So I will let you know what I know about GINA. Typically, however, we file under the ADA. So here we have Section 504 of the Rehabilitation Act, kind of the first major law that was passed in non-discrimination of any entity receiving federal funds. So you could be a private entity, say a contractor, you receive federal funds, you are protected against discrimination on a variety of measures, but including disability under Section 504. And so you have perhaps heard of that term, Section 504. And if you haven't seen it, fantastic movie, Crip Camp, available on Netflix. Love that film, love Judy Heumann, personal icon. I just love Judy so much. And that story of their takeover of the health, education, and welfare building was to pass the regulations implementing Section 504 of the Rehab Act. And the reason why they did that was because it didn't have any teeth until it had those regulations. And then people who were subject to it knew what violations of the law, what that meant, how they were violating it, that they would be held accountable, that people could sue under those regulations. So Crip Camp, fantastic film. All right, Education of the Handicapped Children's Act. I feel like I'm talking prehistoric era as I use those words, but that is now known as the Individuals with Disabilities Education Act, the special ed law that applies in every state in the union. And again, like other laws, state laws can be more protective of children with disabilities in education as well. We also have the Fair Housing Amendments Act. Funny choosing of the words in the order there, but that's what it's called, Fair Housing Amendments Act, which has to do, of course, with your rights for accommodations in housing, what you can do to remove barriers, and so forth. Americans with Disabilities Act. Anybody heard of that one? Yeah, a couple people, one or two. Yeah, that's what I typically litigate under, is the ADA and the California associated statutes. We'll talk about that. And then of course, GINA, the Genetic Information Non-Discrimination Act of 2008. And we see the progression in the years in terms of when these laws were passed. In the grand scheme of the law, it's all really new. It's all still pretty new. The ADA is still being interpreted and reinterpreted. You know, we've come a long way in the last 20 years. I remember I joined the DRLC as a young attorney, and it was what? It was 1998, and the ADA had been passed, just like it actually became effective 7 years prior. And I felt like, oh, this brand new law, it's great civil rights law. Can't wait to litigate and establish the precedent. And that's exactly what we've done for the last 20 years. And it's remarkable. I'll talk in a second about one particular case involving a service dog, but we just established a published precedent last year on a very basic premise of the ADA about the right to train your own service dogs. And it's like, gosh, that's still happening in 2022. The ADA is still being interpreted by courts. It's still evolving to some degree. And thankfully, Congress has not gone in to modify it in a negative way. In fact, Congress has gone in to modify it in several positive ways over the years, which is nice. Okay. All right. And speaking of the ADA, actually, let me go back one. We talked a little bit about Section 504, how that applies to anybody who receives federal funding. Let me talk a little bit about Fair Housing Act, because I don't have separate slides on fair housing, given our time limit. And by the way, this seminar could be an entire week, so I'm really trying to just go over the basics today. There's so much to cover and to understand about these laws, so please bear with me. So on fair housing, in California, we have something called the Fair Employment and Housing Act, which builds even additional protections. But the idea here is if you have a disability, you know, this is one, I mean, very basic non-discrimination component of it. Obviously, landlords can't refuse to rent a unit to you because of a disability or of a family member. That's pretty straightforward. You just got to get good evidence of that. You know, sir, can I get you saying that on video? Great. Can't have, okay. All right. Very good. But you're in an apartment, you know, there's some issue, maybe neighbors, maybe you've acquired a disability and you need, you know, assistance, you know, to go upstairs that doesn't have an elevator. What are your rights? So the general tenet here for fair housing is that if you have a physical access issue, you are allowed to create the accessible path to your place, like an elevator. There can be an elevator or a stair slide that goes up the stairs. You would have to install it and you'd have to take it out once you move out. But the landlord does require you to be able to install that stair lift, okay? And there are lots of entities available, government funding, to help provide the funding to be able to provide those access improvements. I'll talk a bit about independent living centers. They are there to help folks. Maybe you already know all about that, of course, but I know one that I'm involved with in LA, they do a lot of assistance to allow for access for housing. And in this day and age, with the difficulty even finding an affordable place, or using a Section 8 voucher. It's so difficult to then find, have to find one that's accessible is virtually impossible. So the ability to make those modifications to the unit are a very important right. And the other question that we get a lot, and we have a case pending right now of a gentleman with asthma and a heart condition who had smoking neighbors. And so the issue of smoking and the effect on one's disability, what rights do I have on that? And so we are asserting that he had the right to enforce the CCNRs, the code covenants and restrictions on the unit, to require the neighbors to not smoke, certainly in public places. And if he needed to move, he should have been allowed to move his unit as an accommodation. And typically that is a right. They don't have to move you immediately, but the next available comparable unit, they would need to make available as an accommodation, depending on the circumstances. So a couple of points there on fair housing, lots more we could go over, but just don't have the time today. Okay, let's go to the ADA. Title I covers employment rights and non-discrimination in employment. Title II covers state and local government programs, services, and activities. That's the phrase used in the law, and it has to do with everything government does for us. It needs to be accessible. There need to be reasonable accommodations to allow for equal access for those programs. Places of public accommodation, Title III, there's a whole list in the law of what types of places are covered. But it's pretty much, I mean, if you can think of it, it's any place open to the general public that does business, that affects commerce. And hotels, restaurants are obvious, but many, many others. In California, we have something called the Unruh Civil Rights Act, which says that any business establishment of any kind whatsoever is afforded, folks are afforded protection against such businesses. So again, California, other states are very broad in their protections, thankfully. Okay, so let me see where we go next. Barrier removal. So the different things that are required under the ADA: barrier removal, physical access barriers, safe paths of travel, accessible bathrooms. I'm going to guess that this crowd doesn't need a whole lot of education on those kinds of issues. Reasonable accommodations in higher education, in employment under Title I. Those could take the form, so many different forms, including auxiliary aids and services, including effective communication for folks who are deaf and hard of hearing, or even other disabilities, and many different kinds of accommodations. Now, on service dogs, I mentioned that earlier, the point of law that we were able to get an opinion published on just last year is the fact that people are allowed to train their own service dogs under the law. The definition is, the dog is trained to perform at least one task that is related to the person's disability. So physical disabilities, it might be picking something up or opening doors, or psychological disabilities, it could be cornering, alerting the person to folks that are coming because of PTSD, anything related to a qualified disability, any task that serves that disability is what you can train a dog to do, and that dog can be considered a service dog. And we had a judge that disagreed with us and said our dog wasn't certified, and therefore you lose after trial that we thought we won, right? So we went up on appeal, and the Ninth Circuit said, no, you're correct. The law says exactly that. You can train your own service dogs, does not need to be certified. In fact, there is no such thing as a certification of a service dog. You might have gotten one on the internet. Congrats to you, all good. No legal, authority there whatsoever. There is no official registration other than maybe your local animal control, but that has nothing to do with service dogs. So totally get that you've got the thing on your dog that says registered service dog because you want to let people know that it's not a pet. Fantastic. Just just know it's not required and it doesn't have any legal effect. Okay, but you may be asked questions about you have disability. Does that dog perform tasks? You can say yes, they need to leave you alone. It's on your honor. It's the way it goes with service dogs. If you lie about it, you're in California, you're committing a misdemeanor. Okay, but that is the way that it works with service dogs. Effective communication, I'll go back up. That is considered to be communication that's as effective as that with with hearing people, with typical communication. So for deaf and hard of hearing folks, you can get real-time transcription, get a sign language interpreter, online captioning. All of those could be effective communication. How do you tell when it's appropriate? When the individual says, I can understand, we can have a conversation back and forth, just like any people would. And that's the purpose of the law and the regulation, is to ensure that communication. The question I get all the time is, don't I get an interpreter? I want an interpreter for this interaction. Don't I get an interpreter? And I said, it depends on the situation. It depends on the length and complexity of the interaction. It depends on the information that's being communicated. Does it need to have interpretation? Or if it's a short communication, are writing notes sufficient? It could be. It could be, if it's effective in the situation. We get the question a lot in law enforcement. What is the police's obligation to provide an interpreter or other effective communication? And we have to say, it depends. It depends on the situation. It's not always required. And I think that's really important for the community to know. It may be required. And when it is necessary to afford effective communication, like in a class or maybe a medical appointment, absolutely. And it is the schools or the doctor's obligation to pay and provide for that interpretation. Often they say, why don't you just bring a family member? That might be appropriate. If the person doesn't mind and the person is an excellent interpreter, that could work, but it's not required. And the person has a right, particularly in a medical context or some other sort of critical situation, where they have the right to be able to have an independent certified interpreter, certified to interpret at a level appropriate for the interaction. So when we have deaf folks come to our office, we will always get an interpreter to ensure that there is clear communication and that they're at a legal level where they can interpret legal terms. So very, very important. Okay, I could talk forever about any of these, but let's move on. Okay, Individuals with Disabilities Education Act. Our special ed law, and an area of practice at our office that I'm very passionate about because of something called the school to prison pipeline. Has anybody heard that term? Couple? School to prison pipeline refers to kids with disabilities in K-12 education who are disciplined because of, or perhaps not because of, but they have a disability. And as a result of being disciplined, they're excluded from the school community and often get into trouble out in the world or wherever they are sent off to. And they are eventually involved with law enforcement and may go to jail or prison. And if you look at the statistics, I think it's 80% of our prison population has some form of disability. So the school to prison pipeline is a very real thing. It's a great concern. Our office is doing some work in the foster care area right now because it's even worse for those kids. But the idea here is you want to get the first bullet on our slide there. You want to get assessments. We need to know what's going on with our kiddos. And if you have somebody or you're assisting somebody that may be having some difficulty in school, and it may not simply be reading, writing, and arithmetic, but social skills or physical aspects of the experience, emotional aspects, mental health, all of that is fair game to request a free assessment from the school that they must perform. They could refuse to perform it, and you could sue them for failing to do so. But typically, if there's something going on with a kiddo, the assessment is the first step that you want to make that request, and the school then performs hopefully a full psychoeducational assessment on the kiddo and convenes what we call an IEP team. And the first step is you're not automatically eligible for special education. You have to be found eligible by that team. And so you look at the various assessments. Psychoed is typically done by a school psychologist. There's a health assessment. There may be a speech and language assessment. There may be a physical adaptive PE assessment that's done, and any actually number of other assessments. And so the team comes together and it reviews the assessment results and the recommendations of the providers and determines first and foremost, is the child eligible for special education? And there is a rubric under federal law that all states must abide by. Again, different states pass additional statutes that provide additional grounds for eligibility or protection. And the team must find that the child meets the eligibility criteria for at least one of those categories. As long as one category is satisfied, the child is then deemed or declared eligible for special ed, and the team then continues to speak and develop an individualized education program for that kiddo. And that's really the key here, is that every kiddo is different. Every kid has unique needs, as we call it in the biz. And so therefore, the needs are identified, specific goals are provided for the child. They are to be measurable and achievable within a year. And then from those goals, once those are agreed upon by the IEP team, then the team looks at, okay, what's the least restrictive placement for this kid? Can this kid meet their goals reasonably in the general education setting, a typical school setting? Or is it in a special day class on a general ed campus, or perhaps a specialized class depending on the disability? And so based on those goals, the placement is identified, and then the related services are identified. What are the different services that are going to help that child meet their goals and advance in the curriculum? That is the ultimate goal, is to allow the child to advance at their level. It doesn't have to be at typical grade level or average grade level. It's at a year's worth of progress based on their abilities and their unique needs. So that's kind of the world of developing IEPs, super important for a lot of our clients and our children. So, and then finally under IDEA, like the other laws, you have enforcement mechanisms where you can go to court and get remedies very, very specialized in special ed. In fact, the whole system is very specialized, as I mentioned before, because you're bringing an administrative due process complaint in one of your state tribunals. Different states have it slightly differently. I've seen that there's two-tiered states where you bring your first complaint. If you don't like it, then it goes to the state level for some form of intrastate appeal. In California, it's just you file for due process and it's one level. You get a hearing decision if you want a hearing decision. And so what happens is typically you file the complaint, the school has not implemented my IEP, or the school did not find my kid eligible, whatever the issue may be. And then the school district has to, or the tribunal convenes a mediation often with the school district. And so you're allowed to try to resolve it amicably without going to an administrative hearing. But if you're not able to resolve it, then you have the right to get an impartial hearing officer, somebody who's typically state appointed, not district chosen, who hears the evidence of the case. It's a bit less informal than a regular state or federal case, a bit less intimidating, and usually happens in a boardroom at the school district office. But the great thing about the special ed law is you get a decision very quickly. Under the law, you're supposed to get a decision within 45 days of filing, whereas regular litigation could take years, right? So, and then there's an appeals process for special ed, and our kids are ostensibly well protected under this law. Okay, let's move right along out of special ed to our good friend GINA, who has arrived. She arrived in 2008. And as with DM, a hereditary condition, this is a law of great interest to the community here. Title I concerns health insurers not discriminating. Title II relates to employment discrimination. So don't get your titles mixed up with the ADA, they're different. There's also, I believe, a Title III under GINA, which is miscellaneous provisions, which I really won't go into. But so what does that mean, genetic information? What are we talking about? These are the definition in the statute: genetic tests of an individual or of their family members, or if there's a manifestation of a disease in the family of the individual that's affected, either for insurance purposes or employment purposes. Okay. Now, what is a genetic test? I think that's a valid question. I'm not exactly sure. I think that there could be a number of interpretations of that. I will say to you that Congress, like with the ADA, the intent of Congress was broad protection of people, that they're not discriminated against based on, under the ADA, a disability, under GINA, genetic information. So if you feel like that's affected you or your family because of some information passed to an employer or an insurer, that would be grounds to consult an attorney if there's an adverse action. Okay. So health insurance discrimination, what are we talking about? That prevents the disclosure of the information to health insurers to determine eligibility for insurance, as well as to make coverage, underwriting, or premium setting decisions. And looking at the case law out there, there's very little case law on this title at this time. So there's not a whole lot of guidance. You've got the statute itself, these general prohibitions, but not a whole lot of other guidance. But this is sufficient. You've got this. Again, you feel like this has occurred to you or your family, consult an attorney to talk about your rights under the insurance laws in GINA. Okay. Employment, same thing. Prohibiting an employer from requesting, requiring, obtaining, or purchasing genetic information without consent. Prohibits discrimination in hiring, working conditions such as segregation because of someone's status, moving them to a different room or area where they're not with their work colleagues. Of course, improper termination and any retaliation for raising a complaint, whether valid or invalid. And this is true for many of the statutes that I've referenced, that when you complain to the entity at issue, any retaliation that can be tied to that complaint is unlawful. A complaint is protected activity, and it subjects the entity or the employer to a lawsuit. And this also includes labor organizations, unions also may not discriminate on genetic information. Okay. Moving along, I've given a little bit of an overview of various statutes. There's many more, like I said, much more to say. I apologize that my remarks are so brief in this regard, but I do want to get to your questions at one point. Before I get there, I want to talk about the resources that are out there for you to explore these items further, as well as who to talk to and how to talk to them when you feel like you have a legal issue. Okay. So first we have ada.gov, fantastic website that's created by the US Department of Justice, all things ADA. Specifically, I would direct you to something called the Technical Assistance Manuals. And there are a number of other publications that the DOJ put out that in a very plain language, very easy to comprehend and go through, will inform you of your rights in a particular area. The same is true for, say, the Department of Education and other federal departments, that they have these technical assistance to assist folks in understanding their rights. Terrific website. You can even see who DOJ sued and see the settlement agreements that they've gotten with other entities. State government resources, and obviously depends on the state. In California, our Department of Fair Employment and Housing has an outstanding website, lots of great information on there about rights in California and how to assert your rights and file a complaint. So look to your state government entities for the information that they have available. Independent living centers. So I mentioned this before. Do folks know that term, independent living centers? Set of hands? Not a few, just a few folks. Okay, so these, through the Department of Rehabilitation, there's funding that's gone through to every state to create local independent living centers that are basically, and the one I'm affiliated with is called the Disability Community Resource Center. And it's a local social services office that provides a wide variety of assistance to folks with various kinds of disabilities. And if you have not located your local one, or perhaps one in an adjacent town or city, I highly recommend that you look up those agencies, because they can be tremendously helpful in terms of information providing, like I mentioned earlier, assistance with accessibility for homes and apartments, as well as advocacy. There are a number of them that have advocates on staff that will help file complaints, write letters on your behalf when a lawyer perhaps may not take your case or charge you a lot to do it. These ILCs are really, really helpful. So a plug for ILCs across the land. And then I referenced something called protection and advocacy offices. Again, anybody heard of protection and advocacy? No. Ooh, one. All right. Okay, so protection advocacy, again, federally funded law offices dedicated to protecting and advocating for folks with disabilities. I think they changed the name in recent years to be a bit more rights oriented. So what you'll see is Disability Rights California, Disability Rights Texas, Disability Rights Connecticut. All over, every state has I believe a mandatory P&A or disability rights office. Their websites are also fantastic. So in addition to the state government websites, take a look at your state's disability rights office website. Tremendously great materials. And if you don't have one, or it's a weak website, take a look at Disability Rights California. Fantastic, including tons of information on special ed as well. Okay, so that's about educating yourself. Do I have an issue? I think I have an issue. I think I need to talk to somebody. When should I talk to somebody? And you know what my answer is. Yesterday. You should have talked to somebody yesterday. Yes, as you probably know, timelines really matter. Don't let it linger. There are reasons to immediately contact a lawyer. If you feel like you've been discriminated against by certain entities, you might have to file a tort claim or another claim within a matter of months. So it's really important. A lot of lawyers, of course, will do free consultations and so forth, but I really do strongly recommend reaching out to somebody regarding your issue and getting a sense of what your next steps need to be and so forth. So Disability Rights Bar Association, national group of lawyers specializing in disability rights. There should be a listing on that website of lawyers in every state or almost every state. So that's private lawyers as well as nonprofits like ours are on that website. Terrific resource if you're looking for a local attorney. We plug for our Disability Rights Legal Center, our website. We accept calls from all over the country. We will always, if we can't help directly, we always try to make a targeted referral or provide information that can be helpful to you. Same is true for our partner, Disability Rights Education and Defense Fund. They're up in Berkeley, the birthplace of the disability rights movement, some have said. It is, yes. And DREDF is terrific and has a wonderful, again, another wonderful website with tons of information. And they do provide some direct representation as well. And then I had mentioned disability rights, and it says state on the slide, meaning insert your state's name. That's the Protection and Advocacy Office for your state. So these are all typically nonprofits, happy to accept your call. May take some intake information to get through to talk to somebody or get the information you need, but great low or no cost way to get information about your legal issue. Okay. All right. And then other than the nonprofits, kind of the county bars, every county or most counties have their local bar associations. I prefer the first slide, but I throw this in because in whatever legal matter you're looking for, maybe it's an insurance or a trust matter, the county bar association usually has a very good referral service to look to. And of course, direct for referrals. I did not include Google on there. Okay, you can Google and the reviews might be helpful and that's fine. But who knows who's writing those reviews? Of course, word of mouth, direct referrals from colleagues, friends, us, that's who I recommend you speak with. Okay, so you've now got your list of attorneys that you think you might want to work with or you want to approach. What do you do? So I wrote here, it's okay if you don't, but I really suggest this. And I really mean that. I wrote that purposefully to say, look, in a time of stress or difficulty where we have, a lot going on with us or our family, we may not have our crap together, right? You may not have your documentation or your timeline or your list of witnesses. I get it. We all get it. I'm just saying, if you can put that together, it'll move things forward a lot more quickly. So that's suggested there for you. And that's the stuff exactly what we look at. Look at show us the documentation of what you're saying happened. Give us the timeline of when it happened and let us know who was there or who witnessed this and so forth. And that's going to move your matter forward quickly. And then if you have an idea of the types of remedies that you want to look for, that's always really helpful. And you should be telling the attorney, this is what I really want. They may think you just want big money, big money, big money, right? What do most of the people that come to our office want? I want you to change the way that those jerks do business and the way they treat people with disabilities. I don't care about money. Sure, I'll take some money, but for us, it's injunctive relief. It's that order from the court or the settlement agreement that changes policies and procedures, trains the people at issue, provides monitoring so that we make sure that they're doing what they say they're doing. But sure, there's definitely damages out there. And if you can prove up actual damages, meaning out of pocket, lost income, lost, money for any purpose, that's super helpful and will help the attorney evaluate your case. The great thing is under many, if not all of the disability rights laws that I mentioned, including GINA, attorney's fees are available. And why that's so important is you may not have a big dollar matter. You may have a principle of discrimination that you want to fight for that's really important. And I'm going to agree with you. Heck yes, that's very important. I don't need you to have a huge damages case to take your case because I'm going to get paid by the defendant when we resolve this because what they did to you was obviously discrimination, right? So those attorney's fees provisions, while a lot of people are not happy about that, that's what allows these laws to be enforced. It's what allows lawyers to be able to take a lot of these cases that monetarily wouldn't otherwise, be viable, other than us nonprofits who are funded in different ways. But obviously there's a very limited number of us. We get far more inquiries than we're able to accept for representation. So the nice thing is if you have a good issue, you're very likely not going to have to pay the attorney for it. In fact, I might be a little leery of folks demanding payment up front. To me, that would say that you might not have that great of a case, that they see a lot of risk and they want to make sure that they get paid for some of their time. I would like to think that they would be upfront with you and say that to you, say, look, this is not a slam dunk, but I really want to fight for you. I got to get my costs covered. I need some money to be able to do this. That's fair. That makes sense to me. I get that. So that kind of good communication, that effective communication is really important. And really, I recommend a written retainer agreement. There will be lawyers that will say, oh, sure, I'll do that for you. Absolutely, no problem. I'll get that letter out next week. You don't have to pay me anything. Okay, I hope you're being honest and truthful, but they're also probably very, very busy. or maybe they're just saying that to get you go on to the next thing, right? So I really do suggest getting a written retainer agreement that spells out the scope of the representation, rights and responsibilities for you, for the attorney, and so forth, and to get that signed and in writing. Very, very important, and it's enforceable. And then finally on this slide, if you have lawyers that you know or you can find, it's always a good idea to take that retainer agreement and have another lawyer review it, and just let them share any thoughts or concerns that they might see. And we always, in fact, when DRLC gives a retainer, we always say, hey, if you have someone, you should have somebody review this. We want to make sure any questions are answered. And, please, by all means, you have suggestions to change the retainer agreement. It's actually an important point. It's not set in stone. You can negotiate with the lawyer, or you say this wording is not clear. Can you clarify what this means in the agreement? And they should, if they're good, they should be willing to do that for you. Okay. All right. So in the legal process, you've now found this lawyer who you like, you think they're reputable, you've got a written retainer agreement to help assist you. What's going to happen next? After you get them all those documents we talked about, after you provide the basic summary of what happened, perhaps a timeline, list of witnesses, they've got the information they need. What do they typically do next? Typically, they'll write a demand letter or they'll write a tort claim. A tort claim refers to government entities who have wronged you and for whom you're claiming damages. And sometimes it's personal injury or property damage, but it also applies to civil rights claims. So whenever we are suing, say, a California entity, we are always writing a tort claim if we can within that first 6 months period of the incident. And in California, you actually get a second 6 months called a late presentation of tort claim, which is possible. But after that 1 year, if you have not, for some reason, that may be related to disability or hospitalization or mental capacity, after that 1 year, if you haven't filed a tort claim, you're not going to be able to get damages under state law against that government entity. You can still probably go with federal law, which is great, but as a matter of practice, we always want to make sure we get that tort claim in to preserve our rights against the government entity. So either way, whether it's a demand letter to the entity saying, hey, you screwed over my clients, let's talk, you need to do some things differently, perhaps pay some money, we'll see what happens. A lot of cases get resolved depending on the type of entity and their sophistication, whether they engage a lawyer immediately or not. Often a good demand letter is going to resolve your situation. And it all depends. You never know, but we always do it. And we always try to do it in an open way to say, look, we also understand there's two sides to every story, but let's talk, let's figure this out. And it allows you to engage in communication with that defendant to learn their side of the story and see if there's something missing. And then you can talk to your attorney and clarify what the defense is talking about, or what most of my clients say, oh, they're full of what. Right, but it allows that interaction to start taking place, which is good. And again, if it's a sophisticated defendant often with counsel, usually that's going to result in a resolution. So that's good news. We always want that. We want a resolution as quickly as possible, as thorough as possible. And the more you demand, the longer it will take likely to resolve that dispute. So non-litigation complaint, referring to perhaps an administrative complaint with a state entity or a commission or an office of civil rights. That's very possible if you don't want to go the litigation route, not always necessary. Department of Justice has an office of civil rights, Department of Education, and who else? HUD, I think, has an OCR office. So these are civil rights offices at the state or the federal government entities. They get all sorts of complaints of various kinds of discrimination, and they look at every one. It takes them a heck of a long time, but that can result in a resolution. If they deem the complaint to be, possible or plausible, they'll investigate. They'll request a response from the person you're complaining against, the entity you're complaining against. They may even conduct a mediation to try to resolve it. So there is a non-litigation route. Good news. It just takes, often with those OCR offices, it takes a very, very long time. Okay, you ain't got time for that. You want your damages. You want to change policies and procedures, the way this government entity or this business does business. You want to file your lawsuit. Okay, more power to you. Great. Thanks for being an awesome client. Let's go. So we file in state or federal court, and thus begins the potentially very long process of litigation. So you file your complaint. The other side can file a motion to dismiss your complaint. You have to oppose, your attorney has to oppose it. And then the judge rules on whether the complaint gets to proceed out of what we call the pleading stage, that initial stage, right? You get past that, you get into the discovery stage. That's where each side gets to ask the other questions under oath, in a deposition, exchange documents, answer questions in writing under oath, and so forth. The discovery process is intensive. It can be long. If it was a particularly traumatic incident, you know, you or your loved one is going to be reliving that incident. And that can be very difficult, and it needs to be factored in on, you know, whether you go to a lawyer and or whether you file a lawsuit. So really consider, you know, the implications of filing that lawsuit in court. I would say you really need to be serious about it, and understand how long it's going to take, and that it can be tough, and you have to hear a lot of crap coming from the other side on their end of it, right? So just know that going in. That's my purpose here, is that's the way that it works. Want you to know what you're getting into if you go the litigation route. Obviously, a case that's filed, you ain't going to see a trial for at least a year from the time it's filed. May depend on the state that you're in. If you're filing in state court, could be different, could be quicker. In California right now, it's quite a long time. It's at least a year. And then, of course, any adverse rulings can be appealed. If they're appealed, add 2 years to that until you get a decision on the appeal. I've got a case that I got in 2017. This is the service dog case I talked about earlier. We went all the way to trial. I'm proud to say we kicked butt at trial. We really did. We had a great expert. We thought we won. The judge took a left turn and ruled against us on this issue of whether a service dog had to be certified. I'm like, you're kidding me. And part of me thinks that he may have thought he wanted to get an appellate court to tell him what to do. And he wanted that to be precedent. I'm giving him the benefit of the doubt for that really poor ruling, but it's true. It happens. And so that appeal took 2 years, went back, and then we have to go up again on another appeal. So that litigation, 2017, still going on. And there's other litigations that can take longer. I don't want to scare you too much. The typical litigation, as I talked about, will often be resolved at mediation. So after you do, when you do a little bit of discovery, you filed your case, you've done some discovery, there'll be a mediation where you can sit down and try to resolve it, look at the evidence that's come up on both sides, try to come into an amicable resolution without, you know, trial or further work. And that can happen within 6 months. So that's pretty good. It could even happen sooner than that. So that's not bad. And I don't want to dissuade you from bringing a lawsuit if you feel you have a righteous case. And that I think it's 96% of cases get resolved before trial. So there you have it. That's the long road that I'm talking about. Let's see, I think that's the end of our, that's the end of our initial presentation. I'm gonna now pause and take any questions we have here, either in the room or online. Feel free to enter your question in the chat. I am going to strategically go backwards in my slides and remind you guys of this one, that I'm not intending to give legal advice in answering any of these questions. Got to protect my office, right? So I will try to give general information. My information, it should be in the materials, and the last slide has it. Feel free to call our office, submit an intake for our office if you want, you know, really specialized individual information, but happy to take some initial questions.
Okay, I have 3 actual questions.
Where are we? Thank you.
One, does the Genetic Information Non-Discrimination Act under Title I, does this apply to long-term disability insurance?
I am, from what I read, and I am going to disclose, I am not an expert in GINA. I'm familiar with the general provisions of GINA. Discrimination on long-term disability by a private entity, I would think would be. I mean, would the government discriminate on the basis of genetic information? Maybe they could. So I'm going to say likely yes, but I'm not going to say I'm 100% sure on that.
Let's try the second question. I have three. The second one, the Individuals with Disability Education Act, does that apply to private schools as well?
Ooh, I like that question a lot. Excellent question. Does the IDEA, the special ed, apply to private schools? It does to a degree, but a much lesser degree than the process that I discussed. So, IEPs, not necessarily so. There are some provisions where the school district needs to make sure that kids at private schools are being properly served, but it's not as tough a process or as much a followed process as in the public school system. So the answer is partly yes. Now, having that answer under IDEA, which is very limited, I will tell you that based on the ADA and federal and state law, particularly in California, private schools that are open to members of the general public, anyone can apply, absolutely subject to anti-discrimination provisions, particularly in California.
Okay, and my third and last question, your favorite topic, the
You're doing
service
great.
dog. Under county and city licensing, the service animal, because it's animal, would receive a gold medallion versus your standard dog license. Is that necessary or not necessary?
Nope, I'm going to stick to my guns. That medallion is not necessary for your dog to be deemed a service dog. The only test is whether that dog is trained to perform how many tasks? One task. And what does it need to be related to? Your disability. That's it. You don't need any documentation of that. Would it be a good idea to have some documentation of your training? Sure, that's a great idea, not required. The county licensing, bless them for distinguishing between pets and service dogs. That's great. But for it to be, a legal requirement for that dog in that jurisdiction to be a service dog, no, it is not required. We'll come back. Question, we have a question over there. Yeah, go ahead, Monica.
Thank you. First, thanks for joining us today and giving this important presentation. A little deviation from your theme, one of the issues that in myotonic dystrophy is it's a progressive disease. So many people start off as hardworking, able to work, no disability, disease progresses, and it's always a bit of a challenge to understand when one should become disabled and what that actually means legally. Do you have some advice on that? And then also, when you do become disabled legally, what are the ramifications on that financially?
Okay, let me answer that first question. So again, very, very good question. At what point is it actual disability established? So I talked a little bit about this. I kind of made the assumption that folks know most of the definition. I apologize if I shouldn't have assumed that. So the definition under federal law is substantially impairs a major life activity. So substantially impairs a major life activity. And then the statute lists a number of life activities: walking, hearing, seeing, sleeping, reproduction, a lot of different physical bodily systems. It could be almost anything, as long as it's substantially impaired. What does that mean? It's what the courts interpret that to mean. So the difference is in California, the definition is it limits a major life activity. That word substantially is gone. So California, again, more protection here. Progressive disabilities, the same test applies, just at different times, right? So, if any of those major life activities is affected in some significant way where you can say, my life has changed as a result of this, I would argue that that very well could qualify as a disability, a protected disability. If it's temporary, and I understand there may be conditions that are present and then go away and then come back, chronic conditions can be considered permanent disabilities. So whether the symptom comes and goes, like MS is a recognized disability, but there's other disabilities, temporary impairments, not unrelated to the disorder. Absolutely, you know, they're not going to be considered a permanent disability. Breaking an ankle, a leg, or something like that, a hand, it's not a permanent disability necessarily. So there is a distinction made in the law in that regard. The financial implications of having a disability, kind of a broad question. Monica, if you wouldn't mind going back, do you have a little bit of a clarification on what you're asking there?
So the question often comes up is if you are declared disabled, which I'm not actually sure you get a certificate or a medallion. I mean, is there, you know, something that now you're identified as disabled, and you now may qualify for certain services that you weren't prior, I would assume. And then what does that mean if you're still working or partially working?
I mean, I hear you kind of going the, you know, SSDI, Social Security Disability Insurance. I don't know if that's where you're going with that. And I mean, yes, you can be having a recognized disability can make you eligible for certain services, social services, government services, Department of Rehabilitation in terms of assistance with schooling and working. Absolutely. So that's a positive outcome in that regard. But it really just depends on what we're talking about. SSDI, whole other discussion. I did work on that years ago. And I know that there are part-time work programs. So if you have a significant disability, you can collect SSDI and work under a kind of a certain program. To my knowledge, that remains true today in order to promote the idea of folks working. So I'm sorry, I'm happy to talk a little bit further if there's other specific questions in that regard, but that's what I'm hearing on that question. Do we have nothing?
Okay, this one's from Marty. Can you discuss some pros and cons of disclosing a disability to an employer? And should that be done when initially hired?
Yeah, that's really tough. I think I'm going to answer it this way, Marty. It's really important that in order for you to perform the essential functions of your job, that if you need an accommodation to do that you request it. So there's no need for you to come out, so to speak, and disclose your disability. There's no requirement that you do so. In fact, it's your right to keep it to yourself. But if in a work situation, you have to be able to perform the essential functions of the position for which you're hired. That is absolutely the employer's right. They're entitled to have someone that can do the job. But in disability rights law, you are absolutely allowed to have substantial accommodations to be able to accomplish those tasks, those essential functions. So, and those can be a wide variety, again, based on the disability, based on the nature of work. It's really hard to say and come up with a blanket statement. But my point to you is absolutely, if you need that accommodation, not only do you have to request it, make darn sure you have it in writing that you've requested it, when you requested it, and to whom you've requested it. And your employer has to then engage with you in the interactive process to determine what an appropriate accommodation could occur to allow you to perform the job that you've been hired for. Or if you've been injured or you've developed a condition, you know, during the course of your employment, same thing. When you feel like you need some assistance to be able to do your job, you need to engage in that interactive process. And if you fail to do so and they terminate you, I wish you the best of luck, because you haven't made known the fact of your disability. You haven't made the request of accommodation. Should they have known based on discussions you've had with certain employees or perhaps even supervisors, you can make that argument. It's a lot harder to make that argument that they should have known or they perceived a disability. So it's always really, really good to have it documented with your employer, you know, what it is that you're needing to do your job. Sir.
If you had myotonic dystrophy and you were considering getting tested to get a definitive diagnosis, would you do that knowing what you know in terms of questions you may get, a little bit keying off her question about would that information, could that be used in your eligibility for disability insurance?
Mhm.
Could that be used in the classic, please disclose any pre-existing conditions as you're filing for medical insurance?
So in terms of your own personal knowledge, if you're suspecting you may be developing DM, should you get tested? I mean, that's a very personal decision.
Well,
That's a tough one.
I'm not wrestling with that, but I know there are many members
Yeah.
of the foundation who've not gotten tested.
And I didn't mean you. I just meant
No,
in
but
general.
I
Yeah.
was framing it on their
Yeah.
behalf because they believe, I think they believe it's risky
Mhm.
for those other issues.
I mean,
And they're sort of risking their health knowledge
mhm.
from getting the test because of those worries.
Yeah, I mean, certainly there's going to be pros and cons, right? I mean, the desire to want to know what's going on, the extent of, the condition, perhaps tests for symptoms that you're not even aware about. I mean, that's really tough. I hear the question. I want to say I hear you, but yeah, right. So exactly. So would you have your employer do your testing? I probably would advise absolutely not, right? They may offer some health testing and I would want to do it privately to get my own information as best as possible. Part of your question, I feel like, is no matter where I do my testing, is that information going to become available, or the fact that I now know about it, do I need to disclose it? I mean, I think it's really clear under the employment laws, you don't have to disclose your disability. You don't have to disclose your disability to anybody. If you need that accommodation, you can even just say, I have a disability. And the doctor's note can just simply say, yeah, I mean, the question was, do I need to disclose it if I'm filing for health insurance or something of that nature? And look, if you're submitting a document that is allegedly under oath and you have knowledge, I'm always going to advise you to be truthful. And it's your decision, what you're going to do. Obviously, if you don't disclose a condition and then something happens and you're seeking, filing a claim with the insurer and they learn what happened, then they're not going to have to pay you. I mean, so, I'm personally, I'm just very in favor of disclosure, but I understand the concern of sharing information, in situations that can be tenuous, that could work against you. For me, thinking about the employment situation, what I was going to say was, you can just have a doctor say, this person is under my care and has a disability that affects a major life activity, maybe a little bit more detail is appropriate, but you don't have to disclose the exact nature of your condition. You don't have to name it. You don't have to say anything about it. You have a doctor saying, this person, whatever, cannot lift over 20 pounds or cannot walk, more than, 5 minutes. Whatever the doctor's recommendation is that leads to the request for accommodation, that's what the employer needs the documentation for, not the exact information of, the name of the condition. So anything further on that? It's a fantastic questions. You're good for now? Okay.
Chris, we have time for one more question.
I want more time. No. Okay. Should we take a vote on who gets to ask it?
You did a fantastic job of giving a good overview of the IEP process, but you skipped one step. Would you mind going over how a parent might start the IEP process and legally what the schools have to do? Like how long do they have to reply, et cetera?
Okay. I did not skip that step. Thank you. I said the first step is to request an assessment. That's the first step. So all you need to do is submit a request, preferably in writing. Again, document. I think my kid needs to be assessed for special ed. You don't have to say anything more than that. You can submit it to the teacher, vice principal, principal. That's what gets the process started, because assessment is the first thing that you need to do before you even get to the discussion about the IEP, because they need to have that evaluation information to be able to look at from a professional that they trust to say, yeah, this person, this child is now eligible. Now that they're eligible, we can talk IEP.
And what's the timeline? Isn't there a legal timeline they have to respond to that request?
They do, absolutely. I think it's the assessment and then the IEP meeting to review that assessment. Oh, you're testing me.
It's like 30 or 60 days.
I think it's like 40, 60 days.
Okay.
45 days. Thank you so much. Yes. All right. Is that it? That's the fun. I like a special ed question to end on. That's pretty good. I will stick around. Anyone that has questions, please feel free to approach me. I think I have the info on here. Come talk to me. I've got cards. Thanks very much, everybody.
Thank you so much, Chris. Thank you everyone for attending this session.